Hey everybody, this is attorney Kenneth Stevens from the law firm Stevens & Bell, and today I want to talk to you all about construction defects, specifically residential construction defects, because this is a highly litigated area. Now, with regard to Texas, Texas has the Texas Residential Construction Liability Act. And this is a very important act. It was enacted back in '89, and it was kind of a counterpunch to the DTPA. There was a lot of plaintiff-friendly verdicts coming out against contractors, and so this kind of gave contractors an opportunity to limit their exposure a little bit. And this act is really important, and that's why it's important that general contractors are familiar with it. Now, under the Texas Residential Construction Liability Act, it is applicable to any suit regarding a residential construction defect. So, if the person or the company is a contractor, which is defined pretty broadly in the statute, then this law is going to apply to them. With regard to the kinds of causes of action, if it's concerning a defect, and defect is also defined broadly, you can find it in Chapter 27 of the Property Code, this law will apply. So generally, it's pretty safe to say if there's some kind of dispute concerning the quality of work done on a residential project, that the Texas Residential Construction Liability Act is going to apply. Now, this act is very important. Why? Because it has specific requirements that have to be followed before a lawsuit can be brought by a plaintiff against a general contractor concerning a residential project where a defect is alleged. Now, the first requirement is 60 days, at least 60 days before an action is brought, the contractor has to be given notice of the defect. So a letter must be sent to the contractor by certified mail informing them in detail what the allegations against them are. This then gives the contractor an opportunity to investigate and see what exactly is being alleged. Now, during this process, the contractor then has 35 days to go out and inspect the property, further investigate, see what's going on. Now, the whole purpose of this law is so that more of these disputes are resolved without clogging up the courts. So, in this 35-day window, you, the general contractor, you get to go out to the property and in a reasonable amount of time, inspect the property. After you inspect the property, you then get to decide whether or not you're going to make an offer to settle. Try and resolve the dispute. You can also offer to repair whatever the alleged defect is. Now, this is really, really important for you, because if you do make that offer to settle, then they have 25 days, they being the plaintiff, 25 days to accept or reject the offer. And this is very critical, because if they do decide to reject the offer, there's a limit on your liability, a limit on what you have to pay out as a result of this defect. As long as your offer was reasonable, if they reject that offer, they cannot recover more than the fair market value of that offer. That's powerful. That means if you go out, inspect, and you make a reasonable offer and they decline it, being unreasonable, you've limited your damages. Or if they don't give you an opportunity to inspect. See, it used to be with this law that you could actually get cases dismissed if the procedure wasn't followed. Let's say that a plaintiff failed to send you the letter and give you an opportunity to inspect the property. You could file a motion to dismiss and get this case kicked out of court. Now, I think it was in about 2009, you can fact check me on that, the law was changed to where you would now then have to file a plea and abatement, but it would pretty much put the lawsuit on pause until these procedures were complied with. So this is a very, very powerful statute, a very useful tool for general contractors that do residential construction work. I know this area is something that some general contractors stay away from because it can be problematic and is very heavily litigated. But this statute does offer you some kind of protection, some opportunity to try and resolve these disputes without the necessity of ending up in litigation. Appreciate you watching. If you have any questions, feel free to reach out. We definitely want to be a resource to you. Again, this is attorney Kenneth Stevens with the law firm Stevens & Bell, and happy building.